Welcome back to the Law&Crime Network. I'm Heather Hansen, and ladies and gentlemen, this is the witness who is simply going through these emails and showing the judge that they are not hearsay. We're going to bring in our guest for the afternoon, Nicole DeBorde. She's one of our frequent guests here at the Law&Crime Network. She is a criminal defense attorney and a former prosecutor. Hi, Nicole.
Hi, how are you?
I am great. It's so good to have you here. Let's talk a little bit about this witness who is a little bit boring, but that happens oftentimes, doesn't it?
It does, and you want to make sure that the person who is sponsoring these records that are supposedly regular business records or government records is somebody that can actually testify that they are what they purport to be and that they didn't come from somewhere else and other things haven't been added in. As boring as he is, he's important to the case.
Yeah, and especially, you know, we hear a lot on TV about hearsay, and here these records, so far, these emails don't seem to have been written by the defendants. So then that makes it more of an issue of potential hearsay, doesn't it?
Absolutely. And I think this is a really interesting evidentiary question, actually, because just because you can get records in under a hearsay exception, like business records, these are normal things that we would keep, for example, that can be an exception. What is not accepted necessarily, though, are the content of those emails. So there could still be lots of fighting about whether or not what's actually in some of the emails is appropriate for the courtroom. And just because one exception is met doesn't mean that all of the exceptions are met.
And that's why I remember back in law school, hearsay was always the most confusing thing to learn, because to your point, just because the emails get in doesn't mean every sentence of the emails get in. So sometimes things like opinion are considered hearsay, even if the entire record is not. So I'm getting the sense here, though, that we may not even hear the actual content of these emails. They seem to be submitting them into evidence and then not reading them in. Let's talk a little bit about how that can happen in a bench trial. When it's a bench trial and not a jury trial, is evidence handled differently?
It certainly can be. You have to be really careful as a lawyer presenting evidence in a bench trial that you don't drive the judge up the wall, because the judge is going to be responsible for reviewing all of the evidence. And some of these judges just really don't want you spoon feeding that information to them. They want to take their time to review it on their own schedule and read it for themselves. On the other hand, you want the judge to see and hear the things that you think are important. So the lawyers have to make a really important judgment call about how much of this they're going to spoon feed the judge.
Yeah, Nicole, we're going to come right back in just a second and talk a little bit more about this bench trial, but right now we're going to take a quick break. So, ladies and gentlemen, it looks as though the defense has sort of given up the fight with respect to some of these emails. I want to bring in Nicole about that. Nicole, at some point, when the judge continuously is overruling your objections and allowing you to maintain that objection for the record, does it make sense to just go ahead and say, you know, I want to hold my objection, have it noted for the record, but let's not fight about this anymore?
Absolutely. I mean, you know, we know what the judge is doing. She's already made her decision clear. And all the defense wants to do at this point is preserve the record in order to make sure, in other words, make sure that the appellate court, who may very well review this record, knows that they never did agree to this evidence coming in. So sometimes what an attorney will do is say, I want a running objection. That stops them from having to continuously interrupt the testimony and have the judge rule every single time the issue pops up. And this judge has already said, I've noted your objection. I know that it still stands. We're letting this in anyway without need for you to continue objecting about that same thing.
Yeah, and these emails have been discussed and argued for a long time on Thursday, for a long time again today. At this point, we know that the judge and the defense knows that the judge is going to allow them in. And so to move forward and get this case moving forward certainly makes sense. Next step, after these emails are discussed and perhaps entered into the record, next step is going to be an argument by the defense for a directed verdict. Tell us a little bit about what that is, Nicole, and what do you think will happen there?
So what happens when the defense makes a request that the judge give a directed verdict? What they're saying is that we've heard all of the very best evidence that the state has to offer, and we don't think that they've even put in enough minimum evidence to meet one of the elements, at least, of the crime. So we want the court to direct a verdict in this case. In other words, just decide that the state has not adequately presented the case and that the case is over. That's what they're asking for.
And I'm going to go take us back to the courtroom right now because they're having a discussion. When we come back, Nicole, I'm going to talk to you about what you think the judge will do. But first, let's go back to the courtroom.
7, 8,
8. So I'm going to keep one.
And it looks like they're not having such a discussion. So, Nicole, what do you think is going to happen with this judge and this argument for a directed verdict? I have to be honest. The arguments that the defense has made with respect to conspiracy seem strong to me. What do you think?
You know, I think that they certainly raise a good point. The reality is, though, in most situations, if there has just been even a small, tiny bit of evidence, and what we say in legal parlance is a scintilla of evidence to support the state's claim, then the judge is not going to grant it at this phase. On the other hand, if there is a complete absence of evidence as to one of the elements of the crime, that's when the court would grant a directed verdict.
And probably here, these emails may have provided that scintilla of evidence that you spoke about, right?
Exactly. And so when we don't really know exactly what all of the content of the emails which have been admitted before the court are, but if they raise enough information or they raise enough evidence that the court can say, this could be enough, it may not be the ultimate verdict, I may not agree in the end, but it's going to get past this directed verdict phase.
And when we argue for directed verdict, we want to make it clear, it's not on the whole trial necessarily. So in here, there's 3 different counts being charged against these defendants. There's conspiracy, there's obstruction of justice, and there is misconduct by the officers. Each one of those counts can be, she could, for example, grant a directed verdict on the conspiracy, but continue with the case on the other counts, right?
That's an excellent point, actually. And sometimes that's more likely, for example, if you have sort of an all or nothing case, it's very unusual for the judge, especially when there's been a hint of evidence, really, to support the case moving forward for the court to grant something like that. But when you have multiple counts and the judge feels like maybe they've missed the mark, the state's missed the mark on at least one of those counts, knowing that there's at least something more for the state to move forward on, they do have sort of an easier time saying, yes, I'm going to go ahead and grant a directed verdict as to at least one count.
Yeah, and I was looking at the case law in Chicago before we came on, and conspiracy, obstruction of justice is a Class 3 felony in Illinois, which means it's a 1 to 3 year sentence if any of the officers are found guilty of that. And then official misconduct is a Class 3 felony, which is 2 to 5 years. And if it's an extended Class 3 felony, which, to be honest, I'm not clear on, that's 5 to 10 years. So, Nicole, we're not talking, even if the conspiracy charges were dismissed by the judge, and you know what, I think, oh, we're almost ready to start again. Even if those conspiracy charges were dismissed by the judge, there's still substantial jail time that these officers could be facing.
Oh, definitely. I mean, really, and just their lives moving forward are deeply affected by charges of this nature. There's not a charge before this court that isn't serious. So there's a lot for them to work with.
Very good point. Not a charge before this court that isn't serious. Ladies and gentlemen, we're going to take you back to the courtroom where they're continuing with those emails. All right, ladies and gentlemen, we're continuing to follow this testimony with respect to the emails, and these emails are certainly damning with respect to the overall police department. These emails are between other members of the police department, and they seem to be establishing a story that is contrary to the facts as we know them from the trial of the officer. I want to bring you back in, Nicole, and talk to you about this testimony and what's going on with these emails. The emails have to do with other people, Nicole. How does it affect these defendants?
You know, that's a very interesting question. You know, I keep wondering when the emails that the prosecution is laying out are going to actually have something to do with the particular defendants that we have on trial, because right now, it's giving us an idea of what sort of maybe this group as a whole was doing or what the independent perspectives may have been, but we don't know what these individual defendants were thinking because we haven't heard anything from them.
Yeah, it's fascinating to me. You know, there's a lot of things that are fascinating to me here, but that some of these other officers whose actual words are contained within these emails were not indicted, and yet these officers whose words are not contained within those emails were indicted. Do you think that this trial will lead to more indictments on the force?
You know, that's an interesting idea. I don't think that there will be more indictments. I think that there could be additional discipline as it, you know, really comes out into the forefront, although it should have been something that was already addressed. You know, it's kind of hard to ignore some of the things that the officers were saying, you know, in really a public forum, because if you're on a government email system, you can expect that these things will ultimately come to light if anybody asks to see them.
Yeah, we're going to go back to the courtroom and listen to some more of these emails, and we'll come back and discuss them. We expect the prosecution to rest today. Ladies and gentlemen, it looks as though that witness has been complete, and then that means we believe that the prosecution is ready to rest their case. I want to bring Nicole back in. Nicole, what did you think of that witness? Who did he help? Who did he hurt, and why?
You know, it seems fairly neutral, quite frankly. I don't think that the prosecution moved the ball down the field very much. A lot of this information had very little to do, if anything, with the defendants on trial. And really, this is just a records custodian, which means all this guy can do is bring these records and say what they said. But the judge can read these things for herself. I don't really think it added much value to have him testify as long as he did testify.
I agree with you. And then you saw sort of the defense attorneys getting heated in their cross-examination. What did you think of that? Is that effective in front of a judge?
Not really. I mean, and you could kind of hear the frustration in her voice when she responded essentially to one of the objections, I believe it was. You know, she doesn't need to hear it. She can read it for herself. She can make a determination about what legally is appropriate, what's missing, and what's there. So, you know, his grandstanding, I guess, for lack of a better word, is really not something particularly useful in a bench trial.
Now, at this point, we expect to hear the argument for a directed verdict, and that will be through each one of the defendants. They all have sort of separate arguments on behalf of their clients, don't they?
They really do, because, you know, they really need to look, and each of these lawyers is listening carefully to see which evidence in this trial pertains to their particular client. They're going to need to make sure that they raise whatever legal issues directly reflect the problems in the case against their own client. So it'll be interesting to hear what they each have to say.
You know, Nicole, I want to take a step back from the legal analysis and talk to you sort of just about the cultural aspect of this case. You know, the case against Jason Van Dyke, he was found guilty, and that was something that was lauded by a lot of people, that finally a police officer was found guilty for this type of crime. But in many ways, this case is a lot more important and global when it comes to these issues of the code of silence that is sometimes seen in police officers, isn't it?
It really is, and police officer shooting investigations have been done largely the same way across the nation for years and years, really for decades. And now that we have the introduction of things like body camera and audio, really just walking around with each of the officers on the scene, and sometimes as these events take place, the testimony and the evidence in this trial, in these types of trials and investigations, is really changing. And I think that the way these cases will be handled moving forward needs to change as well.
Yeah, I couldn't agree with you more. And it'll be really interesting to see if this gets the same type of coverage, because truly, whether or not these police officers as a whole were getting together and trying to obstruct justice, which is what they're charged with, and trying to form a conspiracy, which is what they're charged with, you know, if they're found guilty of that, it certainly will be a signal to other police departments across the country that they need to be a little bit more careful, won't it?
I think it will, and I think it should really have an effect on the way these departments conduct their own investigations into officer-involved use of force or officer-involved shootings.
Yeah, absolutely. And I think that they are. You know, we want to be sure to remember that most police officers are very good and doing a very difficult job in very difficult circumstances. But cases like this certainly make it clear, to your point, Nicole, that it's important to have an independent body doing an investigation, and the value of these body cams can't be overstated.
I agree.
I think that there's some conversation going on in the courtroom. I'm going to take you back there and see exactly what's going on. All right, Nicole, they are now submitting the various exhibits into the record. And you made this point a little bit earlier, that one of the key reasons that they need to have these exhibits properly admitted is for a potential appeal for the appellate court to look at. What do you think the chances are of an appeal in this case, no matter what happens?
Well, if there's a guilty verdict, obviously the next step for the defense is to appeal the case. And I think that there's close to 100% chance that if there is a guilty finding, that there will be an appeal. You know, if there's not a guilty finding, then there's nothing to appeal. Right. So to me, it depends on the outcome entirely.
Yeah, and to your point, you know, we talked about this a little bit before. There could be guilty on conspiracy or obstruction of justice or the misconduct of an officer. And for each of the different defendants, there could be a guilty on one count and not another. So there's a lot of things for us to pay attention to, especially when we come to this argument for a directed verdict, as to what the judge decides as to each of the counts against each of the defendants. Isn't that right?
Exactly. You know, and all of the little things that we're seeing arguments about along the way are fodder for the appeal, too. I mean, obviously, the directed verdict is sort of this low-hanging fruit. You know, there's going to be very specific points that are made about why the judge should make a certain decision. But each of these objections the defense attorneys have made along the way, and in some cases the prosecutor has made along the way, will be things that go into this appeal later.
Yeah, it's appellate counsel is going to have their job cut out for them if there's a guilty verdict on any of these counts against any of these defendants. We're going to take a quick break, and we'll be right back to continue coverage of this trial. Welcome back to the Law and Crime Network. I'm Heather Hansen, and we are live in the courtroom where they are going through the last of the exhibits. The prosecution is getting ready to rest their case if they have not yet already done so. It seems as though there's not a lot going on in the courtroom right now, so for just a minute I want to talk to Nicole about next steps. Nicole, if the argument for directed verdict is not granted with respect to all of the defendants on all of the counts, which I think we both agree is not very likely, what are next steps?
Decides what kind, if any, of case they're going to put on. Of course, we know that the defense doesn't have to put on any witnesses. I have a feeling, however, in this case, at least one of these defense lawyers is going to present some kind of testimony or evidence in this case. So that's essentially the next step.
What do you think? Do you think we'll hear from any of these defendants themselves?
That is a very interesting question. There is so much information, so many, statements that we've seen in these various emails so far, albeit not necessarily statements from these particular defendants. That makes for some pretty difficult cross-examination oftentimes for the defense. So, oftentimes it's the better move not to encourage the defendant in these sort of circumstances to testify. But as we know, this is a decision entirely up to the defendant.
Yeah, it's going to be interesting to see because I think that we're going to go back to the courtroom. All right, Nicole, we are continuing to go through some of the logistics of ending the prosecution's case and getting on with the defense case. If they decide not to call the defendants themselves, what type of witnesses, what type of testimony do you expect to see in a case like this? It's hard for me to imagine where the defense would go.
I tend to agree. It's possible that there could be additional records that they may want to admit for some reason to show that the records that the prosecution has admitted aren't reflective of the entire story. It's possible that they may want to admit testimony from other people who were there, who saw what was going on, so that their perspectives could be heard. And as you've already pointed out, it's quite possible that the defendants themselves may testify. It may be that there's additional audio or video that we haven't seen, which I would be surprised about, but that could be on their list of things they'd like to show the judge.
I want to talk to you a little bit more about the defendants testifying in a minute, but first we're going to go back to the courtroom because defense counsel is making some sort of an argument. All right, ladies and gentlemen, so now we have the prosecutor trying to get into evidence some reports filled out by the defendants years before the incident at issue and perhaps a year after the incident at issue. Nicole, I want to bring you in real quick before we go to break. What do you think about this argument? It seems as though he's trying to prove that these officers knew how to correctly fill out a report, had done so before, and didn't do so in this case.
I think that that's exactly what they're trying to do, but I think that that's a real stretch. I mean, if I were the defense, I'd be certainly objecting to them bringing in completely irrelevant other cases and what people did in other cases as being somehow related to this case. It'll be interesting to see what the judge does with this. I don't think it's appropriate, and it's full of hearsay, even though likely the prosecutor is not offering it for the truth of what's in those documents.
That's right. We need to go to a quick break. We'll come back to discuss in just a minute. Welcome back to the Law and Crime Network, everybody. I'm Heather Hansen, and this has been some back and forth between the prosecution and the defense as the prosecution ties up their case. You heard the prosecutor say to the judge, I have just one more thing, and she said, I have a few more things. It'll be interesting to see what her things are. But with respect to the argument that they've been having for the past 5 or 7 minutes or so, the prosecution was trying to get in some old reports that some of the defendants had made to compare them to the way that they reported on this case. And Nicole, just as you said, when you thought that that was going to be problematic and not relevant and not admissible, the judge did not admit it. No surprise there, right?
No, I have to agree. It was a good call on her part. I mean, beyond it not being relevant, just getting into these additional reports and the circumstances of these additional reports would be essentially mini trials on cases that really have zero relevance to this particular fact scenario. So I think it was a very smart thing to do, and also likely saved an enormous amount of time.
Yeah, because to your point, and I think that one of the defense attorneys actually argued this, they'd have to bring in the people involved and compare it to this case, and it definitely turns into a trial with respect to those other cases as opposed to focusing on the case at hand. Now, what they're currently seem to be talking about is a piece of Torres, who was the state witnesses who witnessed the shooting by Jason. His testimony, there was a piece of his testimony that the prosecution wanted to strike. How important is that in a bench trial to strike certain portions of the testimony? I mean, the truth is the judge has heard it. It's in the record. Why is that so important to the prosecution at this point?
You know, it's really interesting. I'm not really sure is the answer to that question, because the judge has heard it, and the judge is the finder of fact in this particular case. The prosecution doesn't really have a right to appeal. There's not anything that the prosecutor can do with this besides maybe clean up a record when information has come in that shouldn't be in, or highlight for the judge that judge shouldn't be considering it. But getting into a lengthy argument about excluding it does seem unusual.
Yeah, unusual for sure. We're going to take a quick break, and when we come back, we'll bring you back to the courtroom and see what the judge has to say. Welcome back to the Law and Crime Network. I'm Heather Hansen, and the judge has taken a break. The prosecution has just rested in this case against the 3 officers involved in the Jason Van Dyke shooting and the events that occurred afterwards. After this break, we expect the defense to make a very strong, and when I say the defense, there's 3 defense attorneys, to make a very strong and very heated argument for a directed verdict. Nicole, I want to bring you back. Do you think that there's any one, and you know, it's sort of hard to keep the lawyers and the defendants straight in this case, but do you think that there's any one defendant that has a stronger argument for a directed verdict than any of the others?
You know, it's hard to say based on what we've heard so far, because we don't really know the content of all of the emails that were admitted in this case. You know, I think that each of these defense attorneys has made some excellent objections as this case has gone on. So I'm eager to hear what they have to say on the point of a directed verdict.
Yeah, and one of the things that everyone should be aware of is that these are some of the best attorneys in Chicago. You know, when you do some research on these players, they are major players, and a lot of them know each other, a lot of them know the judge, a lot of them have worked with one another, and even the prosecutors in the past. And that's common for all of us. I know for sure, Nicole, you probably work with the same lawyers again and again and again, and you sort of get a sense of where you can push with a judge or with another attorney and where you can pull back, right?
Exactly. I actually serve on a board with one of the lawyers in this case, as a matter of fact. He does work nationally, and I think that we can expect some very well thought out arguments in this case.
Yeah, it's that's an interesting little piece. It's these lawyers definitely have names for themselves. We're going to throw now to a clip of Steve Maris. Maris testified and introduced these emails that were so vital to the prosecution's case in his testimony. So let's listen to his testimony as we wait for the judge to come back from her break. There's the testimony with respect to the emails. We're going to continue to listen to clips of that testimony. And though it may sound dry, that testimony, Nicole, is vital with respect to these emails, which certainly seem to be a big part of the case for both sides, don't you think?
I totally agree. And I think that we're going to find out a lot more about what's in those emails by the way these arguments are made for directed verdict.
Yeah.
What we've heard so far certainly doesn't give me a strong feeling that any of these cases should move forward, quite frankly, to a verdict. But what we don't know is everything that the prosecution has in those emails.
Yeah, it's a really good point, because we didn't hear all of those emails. The judge hasn't allowed all of those emails to be released to the press. And so Nicole makes a very good point. Even though the defense may not quote from the emails directly, there will be enough context for us to get a really good understanding of what exactly the case is, why these emails were so very important, the ones that we didn't hear about and the ones that we didn't see, and how they play into the prosecution's case. Because remember, it's not just the defense that makes the argument for the directed verdict, but the prosecution will then respond, and I'm sure that will be a little bit dramatic. We're going to take you back to another clip of Steve Maris as he continues to testify to bring in those emails, and we'll be back in just a minute. Welcome back to Law and Crime Network, ladies and gentlemen. That is the testimony of Steve Maris. He is the person who was called by the prosecution to introduce these emails that were so important to the case. Nicole, to your point, we don't know the content of all of those emails, and we will probably hear a lot about that in these arguments that are about to come up. Since we don't know what's going to happen with respect to the directed verdict arguments, do you think the defendants and their counsel are waiting to make the determination as to whether or not they're going to testify personally?
I think they probably are waiting to find out, obviously, what the judge seems to think is important. And she may or may not indicate. She may just say the directed verdict is denied, or she may give an opinion about, what is important to her at that time. And, every single defendant in every single case has an attorney who is listening to what is going on in the courtroom, who will be advising them right up until the moment when they might take the stand about what this evidence means to their case. So I think they're all still watching and thinking.
Yeah, and you make a good point because, a defense attorney's, every attorney's job, it's not like they're just speaking. They're making an argument at the same time. They've got to be responding to the other side's argument. They've got to be responding to what the judge says. They've got to be taking notes as to what she found important so that they can be sure to address it in their portion of the case if necessary. It's certainly a job that sometimes feels like juggling, doesn't it?
Absolutely. There's a lot going on. And it's interesting, too. We were talking about appeals earlier, and when an appellate lawyer reads a record, it just seems like a very controlled environment. You're reading one thing that happens before the next thing and so on. But when you're sitting there in the courtroom, there are 10 different things going on at any different time. And these lawyers are having to make decisions on the fly as evidence is brought in. And you can hear the context developing as you're listening. It's a much more difficult job for a defense lawyer than oftentimes critiquing that work as an appellate lawyer looking back on what was happening.
Yeah, it's a really good point because most firms have separate appellate counsel to look at the record with new eyes. But when they do look at the record with new eyes, to your point, they see it as sort of a story as opposed to with all the energies and the different personalities and the different emotion that's there live in the room.
Sure. And, the decisions that the trial lawyer makes about what to object to and whether or not to try to get certain evidence in affects the very next thing that's going to happen in the trial. And when you're dealing with a cold record or a record that's already been completed and you're just reading it.
Nicole, I got to go to a break. Thank you.